and we should now be broadcasting. Hi, my name's Jason Hadden. I'm a barrister at St Ives Chambers. This afternoon we're going to talk about coming out of lockdown, what is controlling and coercive behaviour, a roundtable on its impact. We have today for this roundtable, we've got Professor Emma Katz, a senior lecturer in childcare and youth at the Liverpool Hope University, and Claire Walker, an extremely experienced domestic abuse consultant, and also Alyssa Howard, a barrister at St Ives Chambers. The background to really Practice Direction 12J is that in the summer of 2016, Mr. Justice Cobb, who had chaired the working group which drew up the Child Arrangements Programme, was asked to review Practice Direction 12J. Practice Direction 12J, for those who don't know, is the practice direction which deals really with domestic abuse. And part of the reason for the need to re-look at PD 12J was because of the all-party parliamentary group on domestic violence in its briefing dated the 29th of April 2016, and also work by the Women's Aid Federation in its 19 child homicides report. That report tells the story of 19 children who were killed by a parent who was also a perpetrator of domestic abuse in circumstances relating to child contact, either a formal or an informal arrangement. The study reviewed serious case reviews for England and Wales, and Women's Aid were of the view that these deaths were avoidable and lessons must be learned from the deaths, and this brought about, or helped to bring about, PD 12J. In her foreword, Polly Neal, the chief executive of Women's Aid, called on the government and senior judiciary to ensure that no more children die as a result of a simple failure to follow the guidance that already exists. And this is perhaps one of the matters which we can discuss as matters progress. She called on judges to take responsibility for their own understanding of coercive control, how it works and how it affects both women and children, and finally to act on that understanding. The amended PD 12J came into force on the 2nd of October 2017, and it applies to all judges. That's circuit judges, high court, district judges, and for the avoidance of doubt, magistrates. And magistrates are those who mostly deal with private law disputes. Recommendation, if you haven't read Practice Direction 12J, and I know we've got a significant number of social workers on this webinar today, go and read it, because every barrister who undertakes private law cases where domestic abuse is a factor will expect you to have read PD 12J, and dare I say, we will cross-examine you on it. So go and read it. I don't propose to take you through PD 12J in any length today. It deals with fact-finding hearings and where they're relevant. But St Ives Chambers did a webinar on this a few weeks ago, and we'll be posting that online in the next few days, and I'd recommend you go back and have a look at that. Part 4 of PD 12J reminds us that domestic abuse is harmful to children and it puts children at risk of harm, whether they are subjected to domestic abuse or witness one of their parents being violent or abusive to the other parent, or live in a home in which domestic abuse is perpetrated. Children may suffer direct physical, psychological, or emotional harm from living with domestic abuse.
Jason, is it all right if I just chip in there for a second?
Yeah, please do.
I just thought it might be helpful to say that it's domestic abuse perpetrators that are harmful to children, and children, you know, are at risk when they're living in a home with a domestic abuse perpetrator, or indeed having post-separation contact with a domestic abuse perpetrator. I just feel really strongly that it's important to name the problem as the perpetrator. Otherwise, domestic abuse ends up sounding a bit like a hurricane, like it's just something that is unfortunate and spontaneously happens, but it is the perpetrator.
And we'll come on to that in a moment, because part of what we're trying to achieve is to remind people or explain to people what coercive behaviour and controlling behaviour are. Coercive behaviour under Practice Direction 12J means, and this is where it gets a bit messy, so this is why I'm going to just take you through this, means an act or pattern of acts of assaults, threats, humiliation, and intimidation, or other abuse that is used to harm, punish, or frighten the victim. Controlling behaviour means an act or pattern of acts designed to make a person subordinate and or dependent by isolating them from sources of support, exploiting their resources and capacities for personal gain. I am of the view, and I remain very much of this view, that few magistrates and indeed district judges actually understand what coercive behaviour or controlling behaviour are. And they are not greatly assisted by its definition as I've set out in Practice Direction 12J. What is perhaps more helpful, for lawyers and indeed social workers on this call, is to give some thought as to Section 76 of the Serious Crime Act 2015, which created a new offence of controlling or coercive behaviour in an intimate or family relationship. And it talks about these factors, and I just set through some of them where you might want to consider. Relevant behaviour could include isolating a person from friends or family, depriving them of basic needs, monitoring their time, monitoring their online presence or using spyware or what they're doing online, taking control over aspects of their everyday life, such as where they go, who they can see, what to wear, when they can sleep, depriving them of access to support services, putting them down, and this is one which it seems to be very common, I see, although very often it's a case of, from the court's perspective, and we can talk about this in a moment, he says, she says, rather than recognising this as being something which dehumanises the victim or humiliates the victim, financial abuse, taking wages, benefits, threats to harm or kill, talk of suicide, threats to publish personal information, and the like. What is so worrying, perhaps, for people listening here, is domestic abuse features in 62% of cases in private law proceedings. And yet in 23% of those cases, unsupervised contact is and was ordered at the first hearing. The MOJ panel on domestic abuse and serious harm in private law proceedings is presently running a consultation. The focus on the MOJ's work is how the family courts protect children and parents in private law cases. Which brings us to Dr. Emma Katz, who sits here on screen. She published earlier this year a joint study, Coercive Control and Post-Separation Fathering, which is among the first to examine children's own accounts of how they've experienced coercive control perpetrated by their fathers post-separation. Emma, how would you define coercive control?
Okay, so it's about taking a human being who is a free, autonomous human being with rights, which is what we would all like to be, you know, and taking that free human being and trying to turn them into an almost slave-like figure or a puppet-like figure who basically exists to serve you. So it's about taking away somebody's freedom, liberty, autonomy, self-worth, sense of self, human rights, support systems, so that they are trapped, they are ground down, they're confused, they're manipulated, and then the only choice they have left is to serve this perpetrator and keep them as happy as possible. So it's a very, very nasty process, and it takes perpetrators a lot of effort to bring that situation about, because it goes against all human beings' instincts for self-determination and autonomy and freedom and liberty. So you really have to grind a person down, make them feel worthless, cut them off from sources of support, make it difficult for them to escape financially, economic abuse, in order to keep them entrapped in that state as your sort of slave-like figure. That's what perpetrators are doing. And for the perpetrator, it's all about gaining control and keeping control. Some will use violence to do that and some won't. And some researchers have said that the ones who don't use violence are actually in some ways more dangerous, because that it makes it harder for everyone around to identify what it is they're doing, and yet what they're doing is still just as bad. The end result is the same, that they've stripped a person of their freedom, liberty, autonomy. But so if there's a bruise, then people find it a lot easier to say that was abuse. But perpetrators are very good at getting control without ever leaving a bruise. But they do it through economic abuse, you know, cutting off your sources of money, cutting you off from sources of support, putting you down, making you feel guilty, making you confused. When you mentioned about talk of suicide, perpetrators will often use a sort of emotional manipulation of do as I tell you, or else I'll kill myself, or that's implied, or I'll kill you, or I'll kill the children, or I'll kill the family pet. A lot of coercive control perpetrators abuse the family pet, which is of course awful for all the survivors in that family. So yeah, it's all about getting control and keeping control. And a perpetrator doesn't usually respect a partner's decision to end a relationship, because why on earth would they respect that? They've not respected that person is a full and free human being. They've wanted them to be like a slave-like figure. So they will carry on trying to control post-separation, and they'll use whatever means they can to try and keep that control going.
Claire Walker, who has over 25 years experience of helping people who are domestic abuse victims. Claire, do people know that they are victims of coercive or controlling behaviour?
Frequently not, no. And that is half of the problem in terms of a victim being able to understand what their lived experience is, really. And you know, just to elaborate on what Emma was just saying there, the Living with a Dominator book, which is the Freedom Programme, which is what I train professionals in and deliver for victims, is the light bulb moment. You get a lot of victims that make contact because the social worker or the solicitor has said they need to come on the Freedom Programme, and then they're in the room thinking that they understand what they've experienced, but then the model gives them the words to describe and explain exactly how they were dehumanized, how they were isolated, how they were humiliated and economically abused. So it's a painful, steep learning curve, and you know, they're thinking that they've kind of sussed it once they've got in the room, but it's still a long journey for them to go.
Part of Emma's research, and something which I see a lot, and I'm sure Alyssa does, in reports prepared by Kafkas, is a comment often that, well, the parties have separated now, so the problem no longer exists because it was the relationship, he said, she says, that type of thing, which has now been gone because they're no longer together, so there's no more problem. Is that right?
Not at all. Not at all. In the first 12 months of having left an abusive relationship, there's 73% increased risk of homicide.
73%.
Yeah. And in the first 6 months, it's up to 80%. So they may not have demonstrated. Sorry, Emma.
Because it's all about control, and if you've broken their control by leaving them, then they escalate their abuse, escalate their violence, and the threat that they pose of killing you escalates because they're trying to get that control back. Sorry, I interrupted. Go on, Claire.
That's okay. And it's in the first 6 months, it's 80% increase. So they may not have done any physical violence specifically during the relationship, but it can happen post-separation. And the stalking, that's gone up 50% since we're coming to lockdown alone. And once we're out of the relationship, there's no criminal law that will protect the victim, and there's definitely no protection if they're having to go into family court arena. And Kafkas can be significantly more damning and judging in their reports.
It's interesting that you mentioned that, Claire, because I don't know whether you find this, Jason, but I often, when I represent survivors of domestic abuse, they often comment that they feel that their abuser is using the court process as a means to abuse them further. And, you know, this is something that brings them great distress because it's a means of continuing to have contact with them, continuing to put them through the ringer. And I was also very interested, Emma, in an article that you've written recently, I think it was published last month, where you were talking about, fathering and post-separation fathering, and the ways that perpetrators can still abuse the victim through the process can also be things like, saying, I've got depression because, mum, assuming most of the time it's mothers, won't let me see you. And, I want to kill myself because I can't see you, or trying to persuade the child to change residence to live with them. And I just wondered what you both thought about how we as practitioners and how the family court can protect survivors of domestic abuse from having the court process as another form of an extension of the abuse that they've suffered in the relationship.
I think a greater understanding and application of Practice Direction 12J, that's not used sufficiently. If it is, not all of the processes are always followed or adhered to. And even in cases where they are, having judges in court telling children that they're liars, telling, as you say, it's predominantly mothers, that they're liars, or doing prohibited steps order, so children are actually not permitted to have any contact with the mother, to give some settling in period for the children to settle in with the perpetrator. And it's just like absolutely abhorrent for the children, and then we potentially get increased mental health issues for children, and sometimes sadly we also get suicides. And that's been in cases where there have been young people, a little bit older, where they've got a pro bono barrister to represent them as an independent individual, and the courts have still thrown it out as they just need to do as they're told.
I should point out that if people want to ask questions, they can ask questions on the Q&A, and we'll try to ask these questions of our experts.
One thing I was going to add is that perpetrators of coercive control do not make good parents whatsoever, because they're extremely self-centered, very narcissistic, and as we were saying, all they want is to get control and keep it. So the child's welfare is irrelevant to them. They'll quite happily throw the child's welfare under a bus if it means they can have more control. And we see this over and over again in the reports. And
sorry, carry on. I just interrupted you then.
No, it's okay. What were you going to say?
I was going to say we did a seminar. Obviously, Jason mentioned it before with Professor Chowdhury, and she mentioned that something she saw time and time again was how the family courts seem to separate the notion of someone being a perpetrator with their ability to parent. And exactly as you said, a perpetrator can't make a good parent, but the family court doesn't seem to be able to separate those two.
A good parent needs to be child-centered. They need to be able to they need to have empathy. They need to be able to put themselves in the child's shoes and think about what is best for the child. But a perpetrator, because of their nature, this extreme desire to control that they have, they can't put themselves in the child's shoes. So they can talk about how much they love their children, they can cry, they can show photos and say, I love my children so much, but that's because they're seeing their children as a kind of possession or a trophy or a status symbol. They're not really thinking about their child's own lived experience, because if what they've been doing for the last several years has been had a horrendous impact on the child's life, and yet they've never seemed to notice that or care about it. So a lot of children, when a coercive control perpetrator tells children's mum, you can't, I don't want you to go out, I don't want you to see this friend, you have to be back by 5 o'clock in the evening or else, then what happens is the children can't go out, particularly if they're sort of under 12. They can't go and see their friends, they can't go to the park because no one's able to take them, mum can't take them. And perpetrators, they often don't tolerate children playing, they won't tolerate children making noise, they won't tolerate children leaving their toys around the house. So children have to shut themselves down, they can't express themselves freely. Some of them even more or less stop speaking in front, at home, because the perpetrator, it's like they never know whether the perpetrator is going to welcome their speech or slap them down for it, either emotionally or physically. So children get used to living in this kind of way where they have to pretend that they don't have any needs, hide their own needs, and keep as quiet as possible around the perpetrator, and constantly monitor what mood the perpetrator's in. So if the perpetrator had any care for those children's well-being, they wouldn't have subjected them to living in that incredibly sort of toxic dictatorial atmosphere. And so, yeah, we see that they've not been a suitable parent through their behaviour pre-separation and then post-separation. You know, trying to coerce children into seeing you when these children are terrified of you, again, is not good parenting behaviour. It shows very little empathy. Or trying to manipulate children into seeing you by saying, you know, I'll kill myself if you don't come and see me, or I'm on antidepressants because I don't see you. It's very emotionally manipulative and putting that on the shoulders of little 10-year-old children.
Yeah, I think. Oh, sorry, Jason.
Sorry, I was going to say, isn't one of the concerns, Emma, and I hear that, but it's almost a theoretical argument. And I say this because what happens is when we go to court, and Alicia will either disagree with me if I'm wrong or agree with me otherwise, is when we go to court, the priority of magistrates and the priority of district judges and indeed circuit judges very often is that there should be contact where it is considered safe for there to be contact. And the actual parenting of a child, other than on a very superficial, maybe there's one session which is supervised by CAFCAS if they can, or they look at some reports, the expectation is that there will be contact, there will be contact, there will be contact, unless really it's domestic violence. And even then, there's a suggestion, and I know this isn't what your study says, but there is a suggestion that, oh, well, if we split the parents up, that's the problem. And it's not a question of the harm which might be impacting on the children. That's just overlooked.
Well, this
is overlooked, yeah. Sorry.
No, go ahead. I was talking before. Go on, Claire.
I was just going to say, I totally agree that that isn't the fact, because as we know, the abuse doesn't stop at the end of the relationship and it will be used as a tool to continue it. But even in cases where there is evidence from the police putting in the court arena, you know, this man is not safe to be around these children because of investigations they've already made, and that's still being overridden, is just absolutely ridiculous. You know, if we haven't got the evidence and the framework to work on, then we could perhaps be forgiven of our ignorance and making a wrong decision. But when we have the evidence, or evidence is refused because the judge is saying, I haven't got time to read that, it's just absolutely abhorrent. Claire,
can I just ask you this question? You've mentioned evidence a couple of times. From solicitors listening and indeed social workers listening, what is good evidence? What works as good evidence to show coercive and controlling behaviour? Because it's quite difficult to work out what that evidence is.
Yeah, it can be, but if the police are investigating, if there's sexual abuse allegations and stuff like that, then they have their way of submitting evidence anyway. But also, if there's already been child protection involved with the family before separation, then you've got child protection reports. CAFCAS will contradict those when it's post-separation. But the actual behaviours that they need to be looking at in terms of the primary victim, i.e. the mother predominantly, and the secondary victims, the children, is not so much what it is that the perpetrator is doing, but what their behaviours are limiting their victims to do, so that they can't go to the park, they can't come to their full fruition, they can't speak freely, and all of those things that Emma was just mentioning there, really.
The difficulty with that is, sorry to be critical, the difficulty with that is, again, it comes down to how we evidence it. A vast majority of mothers in cases such as this don't go to the police, don't go to social services prior to the actual decision to separate, however that comes about. We know that with coercive behaviour, it's not one incident, or it's very rarely one incident. It's an accumulation over a number of years.
Yeah,
we talk about there's merit in mothers and indeed fathers when it is the other way around. The vast majority is it's mothers, but we're conscious of the fact it's fathers on some occasions. Diaries can be helpful. What's going on a daily or a weekly or a monthly basis.
Well, this is what I was going to say, is that the coercive control legislation has a whole list of things that can be used as evidence of coercive control.
That's in criminal cases.
in criminal cases,
Yeah,
but I think the same sorts of things I think may well be relevant. For example, you know, looking at texts and emails that the perpetrator has been sending, you know, that can identify that they're harassing, that they're threatening, that they're manipulative, that they're controlling. Looking at evidence from domestic abuse support services who are explaining the work that they've been doing with the survivor, with the children. Looking at medical evidence, you know, in terms of how the survivor and the children have been impacted, possibly evidence from the school if that's useful, because there'll be so many people around that family who can explain what has been happening. You know, the one among the professionals who sort of get it, that they can give testimony. And you know, things like bank records may show financial control, as you say. A diary could be helpful. There's an app that's been developed by former police officers called The Keep, so KEEP, and that's for survivors to document a history of coercive control, and it's really good. It's a really good mechanism to do that. So they can, you know, that could be used as evidence. But I think more than anything, it's partly a culture shift. You know, there's these. We need to believe people when they say that this is what has happened to them. You know, people will have incredibly detailed and long stories about all the abuse that's happened over a number of years. We need to believe people when they're saying it.
Camilla and Emma Howard, I think, roughly asked the same question, which is part of the problem. Is it's so subtle, sophisticated coercive control is so difficult to evidence.
I think
this has been a problem in the court for such a long time.
Yeah, I think, Claire, you put it in a great way on your website, which I thought was really a great way of describing it, which is like having carbon monoxide in your home. You can't see it, but it's there, and it slowly kills you and its inhabitants. And I thought that was a really good way of describing it. But it's the subtleties of it. And I think also, Jason, I'm sure you've experienced this, where you've had, you know, if I've had cases whereby my client has been the subject of coercive control, emotional abuse, we're always concerned that the court won't get it because it's not physical violence. You can't evidence it with a bruise, and actually it's quite dependent on the judge. I mean, magistrates, I think, have in particular have real difficulties in understanding this. We don't have necessarily police records. Really, it's just the impact on my client and her in the witness box. We might have a few text messages that show somebody controlling when they leave and when they come home and what they're doing and accusing them, and also some other people that may have noticed things. But again, you know, restricting the social environment is another characteristic of it. So it is very difficult, and I agree about the subtlety of it. But you mentioned about having a cultural change, and I just don't know whether, you know, how we can do that, because I wonder whether anything has really changed since Section 76 of the Serious Crime Act actually came into force in 2015.
Yeah, very little.
You know, I'm sure you know better what's going on in the courts than I do, and how difficult it is. Sorry, Claire, go on.
I was just going to say it's a systemic change we need, not just within the judiciary, but within all sectors, in terms of we need to stop looking for black eyes, because that's perhaps, I don't know, about 20% of victims, 100% of victims experience coercive control. And so we need to change the systemics of how we approach it. And instead of saying, but we need physical evidence, if there is no physical evidence, which generally, as we're saying, there isn't, then our systems need to say, okay, so the relationship started 5 years ago, what changed from there? And like Emma said, you know, in the accounts of the victims, you can just pull it out, you can spot it as you're reading through it. And so we need to have our systems that accommodate that, rather than saying, well, he's not been violent, or he's never been violent, or he hasn't been for the last 6 months, or he was never violent in front of the children. When we know about the emotional and psychological impact is far worse than the violence in the home, unless ultimately there's death.
What some survivors describe how their very sense of self was erased by the perpetrator, and when they leave, it's like they're trying to put themselves together again as a new human being, and it's like everything about them that has been erased by that perpetrator through years of abuse. It's so much more harmful than hitting somebody, because it's an attack on their very selfhood. It's destroying a person from the inside out. And you know, you're also going to see that survivors are probably quite traumatized, and you know, it may be really difficult for them to explain, and that is a further sign that this is what has taken place. And another sign that coercive control has taken place is that the perpetrator will have recruited a number of allies to support their story, who will be saying, you know, this person is a great person and such is a vindictive bitch, etc. Because perpetrators thrive when they recruit allies. They're very manipulative, and they're very good at presenting a completely different face to the world compared to how they're behaving in reality. So again, that's a sure sign that is what is happening.
One of the things you mentioned in your report, and I see one of the people has actually asked about this topic, is perpetrators often create a charming public persona. And also when we come to court proceedings, which is very often are 2 or 3 months post-separation, you very often have, and again, it's the sexist reality of this, is Mr. Charming, Mr. Personable, saying all of the right things to Kafkas and all of the right things to the local authority if they prepared the Section 7 report. And you have Mum, who is at that stage where she is building herself back up, isn't able to present in such a charming persona because she's in a different place emotionally, and that gives a significant advantage to the father, doesn't it?
Yeah, and they're quite well, you know, if perpetrators have used financial abuse as well, then they're in a better position to get representation in the arena and to get other professionals to qualify their narrative. And if the perpetrator is high up in their career, or if they work in the legal sector, if they work as a psychiatrist, a psychologist, then the victim is dismissed just by definition that all she is a victim, and she's just this depleted woman. And then there's this upstanding, successful perpetrator in whatever role and arena he is in. We need to stop taking that face value and have a look at the evidence. And sometimes that will only be in the personal statements.
And we need to ask ourselves, who has the power and control in that relationship? You know, who is setting the agenda? Who is scared and who is not scared? You know, who has control of the money? You know, who is calling the shots and who is desperate? You know, we need to really identify what is going on behind those facades, as you say. And perpetrators, because they're so drawn to power and control, they often end up in positions where they exercise a lot of power and control, you know, high up in psychology, high up in the police, etc. So they can be in some very powerful positions. But as you say, we must look beyond that, because I guess the whole point of this is to do what's best for the children, and allowing the children to their lives to continue to be dominated by a coercive control perpetrator who is really invested in using them to further their mission of getting control. That's not in the best interest of the child. And we know that, you know, studies have shown that contact that's been forced doesn't have positive outcomes on the whole. You know, it has negative outcomes for children. If you try and push them into seeing a parent who they're saying they do not want to see, then that, you know, there's a hope that somehow it will all resolve itself, but studies have shown that really does not end well, and that the children are harmed by it, and it doesn't lead to a high quality parenting relationship. You know, you have to look at what the relationship with that parent has been like historically. You know, is this a parent who's shown any interest in the children's emotional well-being pre-separation?
And it's interesting that the children's voice is often lost in this. If you read, you know, Kafkas or local authority reports, there's often a cursory line, you know, just a generic line about the impact that this behaviour has had on children, rather than looking at this particular child and what impact it's had on their life, you know, on their psychological well-being. But, you know, this seems to also be a tendency in criminal proceedings, because, of course, in accordance with the criminal law, as far as I understand it, a child can't be a victim of coercive control, whereas surely the children are also victims of this behaviour. They're also
100%.
victims of coercive control. Should the law be amended so that children could be victims of coercive control?
Yeah, absolutely. It's churlish, to say the least, to not have it already stated in there. And anybody who is understanding in this arena would be aware that they are, whether it specifies it in the law or not. But the wishes and feelings of children are, even if they are written up and heard and observed, they will still be overridden in some of those reports that you mentioned. And it'll be on the term of, you know, the non-abusive parent is coercing the children to say, I'm frightened of dad, I don't want to have contact, or I want contact supervised, or I just want a little bit. You know, their wishes and feelings are frequently not represented, their voices aren't there.
Which is out of line with the UNCRC, which we as a country have signed up to, which says that, you know, children should have a say in matters affecting them, and you know, that their view should be given weight in accordance with their age and maturity. So yeah, I think we have to be so much more comfortable with the idea that children can make up their minds not to see an abusive parent. I presume that if a child had been sexually abused by their father, if their father had been raping them for many years, then we would accept that that child would have a right to say, I never want to see this father again. He's been raping me for many years. I would hope that we would accept that.
Not if parental alienation is in the arena.
I was going to say, yeah,
indeed, yes.
Where this comes to, the ascertainable wishes and feelings of the child are one of the factors. Section 1.3 of the Children Act was the welfare checklist. But it seems that it's easier for the courts to understand that where there's been violence or abuse, as you explain, but less so where it has just been, and I say just been, and therein lies the problem, where it has just been domestic abuse of coercive or controlling or bad parenting, which falls within all of that, where the courts say, well, and I've got a case at the moment, where the courts say, well, look, we must strive to make sure that there is contact. It must be the mum's fault because she must be alienating the child in some way, or, you know, we don't understand why the child doesn't want to see dad. There hasn't been violence. It seems to be that understanding.
Yeah, absolutely, all too often. But whether it's just, as you say, just in the remits of coercive control, or it is other aspects of abuse against the child directly, you know, the rights of the abusive father seem to take precedence regardless.
It's enormously difficult because we're working in a dysfunctional system. You know, we're, you know, people who have a good understanding of domestic abuse, they're trying to work within a system where they're hitting a brick wall. Where, you know, the system doesn't seem to be understanding what is going on, and so really negative outcomes are happening frequently. It's so difficult to know what on earth would help unless that system goes through, as you said, Claire, just absolutely systemic change.
Can you explain the impact on children post-separation of coercive behaviour? And I say this as having read one of your pieces, Emma. It talks about the confused child saying, yes, I love dad. Yes, I want to spend time with dad. But the reality might be something much more complex.
Well, it was that case I'm talking about in that paper is two siblings who I interviewed when they were 12 and 14, talking about what dad had been like a few years earlier when they were a little bit younger. And they said how every weekend they'd gone to have their court-ordered contacts with dad. And, you know, dad was a very middle-class professional person, and he would spend the entire time saying, your mum makes me cry, your mum makes me do all these things, it's all your mum's fault. And then he would say, you know, I have to take antidepressants because I can't see you enough. And then he would say, you're the only ones who really love me. And so these poor little girls, about 8 or 10 years old at the time, you know, being put through a sort of emotional ringer, and when they got home after these weekend visits, the younger one would be on the sofa every Monday, unable to go to school, just distraught and crying and crying and crying into her mother's arms. And but then the next weekend back to dad's again, and again he'd be calling them up in the week, you're the only ones who really love me. So in a way what he was doing was he was refusing to take responsibility for his own mental health as an adult, and saying all the burden of keeping me okay falls on you. You must basically do what I say or else I won't be okay. And so these girls were made responsible for his well-being in a way. And one of the girls saw a counsellor who was who she said the counsellor helped me to see what dad was doing, and it was then that she started to realize that this is actually really manipulative behavior. And because before she'd known how bad it was making her feel, but she couldn't articulate it. It was a feeling, but she didn't know what it meant. But the counsellor gave her the understanding that somebody behaving like this is very manipulative behavior, and she realized that she didn't want to keep being subjected to this. So she decided to break off contact. She was about 12 at the time. Now, had dad taken this back to the family court, then it's quite possible that he would have insisted that contact carry on. But by this point, he'd met a new partner, he'd fathered a new child, and he was primarily focused on controlling them. So she was able to get away. But of course, if he'd have insisted, then she would have been trapped, still going to see him until she reached 16. Her little sister was the one who was very confused and was just saying, I do want to see dad, but I don't like the way he behaves. And one thing she said in her interview was, I just wish that dad would focus on me during the visits. He just talks and talks and talks about how he feels. He's never interested in me, which of course is like a classic statement from a child of a narcissistic parent, and that the younger sibling was still being harmed by that contact when I did the interviews, and she knew it wasn't good for her, but she hadn't quite yet she hadn't had enough help to understand what was going on yet. She hadn't seen that helpful counsellor, the younger one.
Speaking,
we don't have counsellors. Sorry, Alicia.
No, I was
the resource.
Yeah, that's the problem. And I mean, speaking of counsellors and support systems for children, I'm just looking at the chat, and somebody said there's nothing straightforward about the issue, because the children struggle if they do still see the parent, but struggle if they have less contact. They need support from childhood to navigate a relationship with a parent who practices coercive control. Now, I know that, as Jason mentioned, there are a lot of social workers listening. What can social workers do to support children who are going through this process?
I think, like in any situation of support, is listen to what the person is saying. So today it might be, I want to see dad, and that might change next month, and allow them to sort of explore it at the rate that they are able to, or wish to, or don't wish to. And when I do the lectures for social work students at universities, the majority of the feedback I get from students is, why are we only hearing about this on the third year of our course, or the second year if they're doing the masters? And so in terms of those systemic changes, it's in the education of us as a society, but us in our practices, as well as in our policies and procedures when we get into whichever sector that we do. We need to listen and respond.
The difficulty with
I couldn't agree more.
The difficulty with that, Claire, often is if it's the purpose of a Section 7 report, CAF might meet with the child once.
Yeah, or at the moment, 20 minutes on Zoom.
Yeah, that's right. And we'll come to a view with regard to the next 12 or 14 years.
Yeah. Nobody can achieve that. Even with the best will in the world, nobody can achieve the next 12 or 14 years of an individual's life, from such a short intervention.
One thing I was saying in the paper as well is that I think that children have a right to information about coercive control because they've been through it, and yet nobody is explaining to them what it is they've been through. So they're left struggling without a language to explain what they've been through, or to explore it emotionally. And I think that if we're not willing to say this behavior from your parent, you know, usually dad, but occasionally mum, this behavior from your parent is not acceptable behavior, you know, this is not good parenting behavior. If we're not willing to say that to the children, then they're going to grow up thinking that this is acceptable parenting behavior. And so why would we want a young adult who thinks that, you know, extreme emotional manipulation and extreme control is normal behavior, you know, that's normal family behavior, that equals love? You know, when we say to children, well, these parents, they do love you really, what we're saying is that somebody who abuses you is showing love. We're saying love equals abuse, abuse equals love. And I think we need to, you know, the perpetrator has violated our, you know, everything that we think parenting should be. You know, they've used the child to meet their own ends. That's the opposite of what parenting should be, you know, where the parent should support and nurture the child. So, and I know that's easy to say, but obviously sometimes very hard to do when you actually have children with minds of their own, but that is what we should be striving to do as parents. So the perpetrators, they violated all the norms of parenting, I think, and we can't keep pretending to these children that this was normal parenting or that this was okay, because we're just sending them these terrible messages when we do that. I think we need to be able to say to them, this is what you should be able to expect from good parenting, and then they'll start to be able to make critical decisions for themselves about, this is behavior that I will accept and this is behavior that I won't accept. You know, I will allow people to treat, you know, if people treat me this way, then that's okay, but if they treat me that way, I won't accept that. And I think that's very empowering.
Should CAFCAS or social workers at local authorities, when preparing Section 7s or Section 37 reports, should they then be having a checklist? I had a case recently where a boy aged 10 went into school, Childline did a presentation, and in the presentation there were slides, and he went home to mum and said, that's contact with dad. And it had been slapped in his face for the first time, apologies for using the phrase, but for the first time he had this recognition that that was bad parenting. Mm-hmm. So is that perhaps something that CAFCAS or social workers should be discussing with children, so that actually children understand the discussion? Bear in mind, we know that courts sometimes struggle with these. Yeah. Should we be spelling it out to children in that way, or would that be creating other problems?
Well, no, professionals have to have a good understanding before they can do that themselves. They need a lot of training. Go on, Claire.
Yeah, I was just going to say they do need a lot of training, but an understanding. A checklist is useful, but there's no size one fits all size thing anyway. So it's needing to have the integrity and the understanding to be able to draw from that what is on the checklist and what they're seeing and is presented to them. But if we put it in our education systems, age appropriate all the way through education, to give children the words to explain what this is and what that is and why they might be feeling this way or that way, then that can only be for the greater good, because it's just intergenerational otherwise, isn't it? Because like Emma was just saying, the things that they're understanding about what a healthy relationship then goes into their own relationship. And then we see them again in the next generation on.
Domestic abuse organisations, which are horribly underfunded but often brilliant, they have a really good understanding of coercive control of domestic abuse, and it would be so great if they had the funding to extend their expertise to supporting children in these situations. Because as you were saying, Claire, when women come into the Freedom Programme, they think they understand what they've been through, but there's still so much more they need to understand. And if there were similar programmes available for children that were age appropriate and that were much more widely available, for different age groups of children, I think that would be really transformative. But these services need more funding. But yeah, I think that the domestic abuse organisations they get it. You know, when an adult victim says things like, well, they love me really, or oh, it isn't that bad, or it's my fault, I provoke him. Hopefully, if we'll be able to recognise, no, none of that's true. They've been manipulated into thinking that way. But when children say these things, we tend to take it at face value. When children say, oh, it's not that bad, or it was mum's fault, she provoked him, or if only mum had just shut up and done as she was told, then none of this would have happened. We tend to sort of let that pass, and children need the same level of support as the adult victims do to unpick all the manipulation that the perpetrator's done in their head.
It's interesting because you often find that the recommendations from CAFCAS or from social workers are actually focused on the perpetrator, you know, undertake a domestic violence perpetrators program. Sometimes you'll see a recommendation that the survivor should go on the Freedom Project and the rest of it, but it's, you know, I've never seen any recommendations that a child should be given support or counselling to deal with what they've been through. So perhaps that is something that needs to change.
I think so.
Yeah, because it leaves them. Yeah, it leaves children voiceless and invisible.
When we talk about training, though, it's also the courts clearly need more training, more understanding of what coercive control is, and also the impact, not just which is in theory part of Practice Direction 12J, but the impact not only on the survivor, but also the impact on children. Because I don't think there's that much understanding from the court as to the impact coercive controlling or indeed domestic abuse has on the children, not just now, but over the period going forward.
Yeah, absolutely. I was recently having a conversation with a magistrate, and he was saying that a lot of his colleagues will refuse special measures and stuff like that because they want to see the victim and the perpetrator go head to head, like it's some kind of cockfight.
Yeah.
This demonstrates they have got no understanding of the level of fear that creates. And a court is an intimidating space for people that aren't in it in a regular basis anyway. Yeah, and it's just an additional layer. So training. And those judges who go into retirement and then they've got an interest in a case, or the authority needs to manage the waiting list and the times for hearings, coming out of retirement and being permitted to put their misogynistic views on the situation, and also insisting on always hearing that case when it comes back to court. So it doesn't give the victim, the primary or secondary victims, the opportunity to have a fair hearing, because they've already got someone who's biased and for some bizarre reason is adamant on being there to make sure that their first instructions are sustained.
Do we want to go through some of the questions?
Yeah, I was just going to do that now.
Up, but I can't see them in full.
All right, let me try my best. Could you provide guidance on what, as practitioners, we should do when children are being emotionally manipulated by the perpetrator and are voicing that they want to go to see the perpetrator? I think we all have cases like that where the perpetrator is encouraging the child, but the contact's not very nice. And we're finding that the court simply listen to this voice, and we are ignored the abuse still continuing post-separation.
We need to put protection in for the children, and some of that is education, some therapeutic support, because it's not as damaging, but it is also going to be damaging if a child is in conflict and they acknowledge that there's been some horrible times with the abusive parent, but they still want to have contact. They're in conflict and they need some assistance on unpicking that and understanding that better.
Claire, the reality is it never happens. The court will just simply make the order, and the order would be complied with, and that's the end of it.
That's it. So why do we have human rights?
Yeah,
basically.
Yeah, I know. Yeah. And I've even had cases where mums who have turned around and said, this is becoming quite difficult for little Johnny, and as a result, I'm going to send little Johnny off to counselling, and then mum be criticised for sending counselling as if that's part of some agenda.
Yeah. Of course, because the perpetrator will totally twist that. Yes. It's so difficult because there's all the knowledge is there about what is best for the child. You know, there's decades and decades of research on these issues. You know, and the guidance is there, as you say, Jason, with the various Practice Direction 12J. But if we aren't implementing it, if we aren't understanding it, if we've closed our ears to it, I think there really is a terrible limit to what we can do. Because just coming back to Claire's point, systemic change is needed, and otherwise we continue banging our heads against a brick wall. I mean, have you ever had experience of getting a judge who is totally dismissive of domestic abuse and thinks it's irrelevant? Have you ever had experience of getting them to see its relevance? How have you put it off?
I think it's very difficult, and Alyssa can join me in a minute. I think very often you argue for a practice direction 12G. There needs to be a fact-finding hearing, and courts turn around, shrug shoulders, because Kafkas, and it's often because led by Kafkas, has said, oh, well, it's just a he said, she said, it's the end of the relationship, they're as bad as each other. And as a consequence, you then try to bring it into the final welfare hearing. And try and bring these matters in. Some courts will turn around and say, not interested in any of that. Others will let you pursue it, and you kind of doggedly try to pursue it, which certainly I always do if it's relevant to that case. Alyssa, what would you say?
Well, I've had actually a case I've done recently. We had a preliminary hearing, which was before a deputy district judge, and there were a series of very serious allegations, including rape, 2 allegations of rape. And the deputy district judge listened to counsel on the other side, who was making the most ridiculous submissions that, frankly, I would never make. If I was representing, it wasn't you, Jason. You'd never do that. But, you know, things like, well, she didn't report it at the time, she went back to the relationship, and so on and so forth. And the deputy district judge, in front of my client, who's a survivor, was very dismissive, well, you know, giving an indication on what he thought about the allegation she was making. She left the hearing absolutely devastated, because she said, you know, I'm not going to be believed. But fortunately, what happened was we had a very experienced circuit judge actually hear the fact-finding hearing, and we got findings on every single allegation she made. But she was ready to throw the towel in, you know, at that point, because she said, I don't want to go through this. I can't bear the idea of being in the witness box, being questioned, being accused of lying like this, and clearly the judge isn't going to believe me. What's the point? And I do think there does seem to be a tendency to dismiss things at an early stage, which is completely inappropriate when you haven't heard either of the parties or looked at any of the evidence, police disclosure, and so forth. And I do think that's extremely dangerous and damaging.
Isn't that because very often the courts are simply, in private law cases, trying to have an outcome which is that the perpetrator will have contact, because it's in the child's best interest for there to be contact. So we want to get from A to B as quickly as we can.
Yeah, I completely agree with that.
Do the courts think that there is any level of hideous parenting that would mean that the child shouldn't have contact with that perpetrator? If the perpetrator was chaining them up in a cupboard and whipping them, would that be considered bad enough parenting for contact not to be in the child's best interests? I don't quite understand.
I hardly ever hear questions raised about parenting, I have to say, which is astonishing, really, in the context. The question of the perpetrator's parenting, even after findings have been made against them, is rarely raised and looked into. It's simply, well, go on a programme and we'll start with supervised contact and build it up from there.
Immediately. Go on the programme, but we'll start with supervised contact immediately.
Yeah.
And the programme will run aside it, rather than you must do the programme, improve, and then we go to supervised contact.
Yeah, and many perpetrators don't respond well to perpetrator programs. It's beneficial for some, but there are some that get nothing out of it. They really have no interest in changing, and there are some who perpetrator programs will say straight away, we cannot work with this person, they're too dangerous.
And often they're very tick box from what I've seen. As an independent reviewing officer, conference chairs, how can we progress positive outcomes for children when the understanding of the principles of control and coercion remains so lacking in so many court sessions?
Again, it's got to be about the systemic changes, training, policy and practice.
In your opinion, why do you think the percentage, 23% of unsupervised contact ordered at the first hearing, is high? Are the initial safeguarding checks insufficient prior to the first hearing? I think, yes, they are. And also, I don't think many people realise, mums or dads, realise how important that short telephone call with Kafkas is.
Yes.
But they need to set out in detail, and I say in details because as barristers will say, oh, they never mentioned that previously when it goes to a final hearing or a fact find. when they have to mention in detail their concerns, if they have concerns about the other parent. And I think, again, the court's dynamic is to get to A to B as soon as possible, which is for contact. Alicia?
I agree with that entirely. I think it's incredibly important. The Section 2 safeguarding letter tends to be dismissed. You know, think, well, it's not, you know, don't worry about it. It's not a full Section 7, but actually it sets how the proceedings are going to run, the course of proceedings. You know, does CAFCAS recommend a fact-finding hearing? What are the next steps? So it's crucially important. And I always mention that to my clients when I have the chance to, before a hearing. But you're exactly right. It's often overlooked.
Should psychological and other clinical assessments play a larger part? In the 90s, when dealing with extreme DV and intractable hostility cases, such assessments were always a consideration, but less so now in private law cases, particularly in my experience. And I pause because we discussed this a little bit with Professor Chowdhury in the last lecture. It depends how good the psychologists are and whether they are proper experts in this or have another agenda themselves.
And their understanding of coercive control.
And where it moves to alienation and it's there.
Because how much are psychologists trained on understanding coercive control when they're doing their degrees? I mean, you said that, Claire, in both our experiences, I think social workers have had very little teaching on it, which is astonishing when you think that it will be in at least half of their cases.
Yeah.
To what extent is a psychologist being trained on it?
Anything else anybody would like to mention in closing?
Well, I don't know whether we've got time for this, but seeing as our subject matters coming out of lockdown, perhaps we could just quickly touch on coercive and controlling behaviour in the age of Corona. And I was just interested to know what you thought, what is going to be the impact upon survivors of coercive control when they've, you know, been in lockdown probably for some time before the government imposed the restrictions. What could be the lasting impact on survivors of coercive control given the situation we currently find ourselves in?
I'd say increased deaths would be, as we witnessed at the beginning of lockdown, because if a victim is in lockdown with her perpetrator, then the perpetrator knows that physical space level of control is not going to be restricted by government anymore. So they need to up their game. And I think there will be more we know there will be more victims reaching out for support, wanting to flee, needing somewhere safe to go. So perpetrators will just up their game.
And children will have been, you know, unable to do the things that they normally do to give them some respite from the perpetrator. You know, often for the children, school is a lifeline because it's time away from the perpetrator. Sometimes they're hiding themselves in the toilets at the end of the school day rather than going back to the perpetrator, or hiding in the library. And so for children, it's become, you know, much more intensified, and then that will manifest in the children's mental health. And when children are presenting with mental health difficulties, you know, we must ask the question, what is behind this? You know, what have you experienced that has led to this?
And also, isn't part of it going to be, children haven't had an opportunity to go somewhere else to voice their concerns, nor have mums or dads, if it's that case around as well. And also, it's given the rules which the government have put in place have actually given power to the perpetrator, haven't they?
Absolutely.
They've created more weapons for them.
It's a gift almost for, you know, perpetrators of this kind of behaviour. You know, I've had I'm a member of several, you know, mothers groups and things on Facebook, and I've been surprised during lockdown. Well, not, you know, sadly, probably not surprised about the amount of posts that people have put, you know, how their situation has worsened during lockdown because they can't call because the perpetrator's in the room. Anytime they try and leave, the perpetrator hears. They can't contact anybody for help. And really, you know, they're in a situation that the perpetrator has tried to create. They can't see anybody else. They're stuck in the house. There's nowhere to turn to, and you know, nowhere to go. So it's really a gift, I would say, this current situation for perpetrators of coercive and controlling behaviour.
Yes.
Yeah,
There's
and I think
so much more we could be doing as a society to stop these perpetrators, but we're not doing it yet.
No, we're waiting for the victims to sort it out.
Yes.
Any other points anybody wants to raise?
I mean, I've got lots of points to raise, but I'm aware of the time.
I think we've taken about an hour of people's time. Can I thank our guests? Thank Dr. Emma Katz, thank Claire Walker, and obviously Alyssa Howard for her time. And again, thank you for viewing. We're going to try and see if we can get this video put up online in the next few days. But thank you very much for your time this afternoon.
Thank
you. Thanks.